All right, it's time for this week's Legal Lowdown, and I'm joined in studio once again by Attwood Marshall Lawyers Estate Litigation Senior Associate Duncan MacDougall. Good afternoon to you, Duncan.
Good afternoon. Thanks for having me again.
We're continuing this conversation. When someone passes away, the family home is often one of the biggest assets in their estate, and it's the thing for me that is the tension point. It's the friction point. It's got to cause the most disagreement, right?
It does, yeah. It's the one asset that carries the most emotional weight compared to anything else, like a bank account. Yes, there's money sitting there as well, but some people make it out to be their home,
Yeah.
And it's dealing with that and dealing with the administration of the estate, which it can get complicated.
And I guess it's one of those things you've got. Not warring factions, but, siblings that don't see eye to eye, or family members, even no matter how distant they are, that may not, they might have different views in place, I guess, about what should happen to the property.
Yeah, and there's always this expectations and sense of entitlement as well that comes into play. A lot of the times we see people say, well, mom said this, dad said this, I can reside here for X amount of time because I've been either residing there for a certain period, or
I've been looking after
them for quite a while. But when you've got an administration of the estate to undertake, that's when executor is kind of stuck between a rock and a hard place. They want that estate to be finalized.
Yeah.
They want to continue making sure their duties are up to scratch. So when you've got somebody in a property that's technically owned by the estate, it's held on trust by the executor until such times that it's sold or transferred or otherwise. They're going to have to deal with that either beneficiary or they're going to have to deal with that person who's residing there.
Does this happen often? Because the house next to mine sat not empty. It was a house where the family, the parents that lived there into their 80s were quite good at hoarding. And so a family of possums and rats moved in, and we lived next to this house that sat empty, full of stuff, for years because the family could not see eye to eye. One felt like they had more of a claim over it. And because I thought that if you had a will in place, or if you had your wishes put in place properly, that was ironclad, that there would be no loophole, I guess.
Yeah, well, it comes down to the terms of the will itself. Even if there was a will, there could not have been a will, or the will is silent on those sorts of things as well. So and that's where we see most of those issues creep up, especially when you've got a property that's remained dormant and kind of in limbo during the course of the administration. You run into situations where the executor again is trying to sell it, but then there's this crossroads that exists there, and that's only going to increase costs substantially and exponentially, especially on the legal side, especially when you're trying to come to some sort of arrangement there. Now, there's things that you can do during that to avoid any sort of court proceedings, and that may be some negotiations by the estate itself with that person who reside there. But it's only going to increase those costs to the estate itself because you're going to have ongoing rates. You're going to have ongoing maintenance costs.
Yeah.
You're going to have things like capital gains tax to consider down the track as well. Generally, there's an exception there if it's sold within the first 2 years.
Yeah.
But obviously, that changes things if it's remaining dormant for extended periods of time.
If you would like to ask Duncan a question, he is fully qualified and very experienced. He is our senior estate litigation senior associate from Attwood Marshall Lawyers. 133 882 is the open line number. Thanks to Watch Smoke Alarms, 133 882, or the text line 0499 880 882 if you've got a question you'd like to ask Duncan. Perhaps you're going through a similar situation. I guess there's something you touched on before is like if a house, if someone continues to live in a property after the person has passed away or whatever, perhaps it's a carer or a family member, whoever it might be, what happens if they refuse to leave? What sort of legal grounds do you have there?
Yeah, and that could very well be the case. I see it all the time. We have estates like that all the time where, example, we act for the estate and we want to make sure that we're administrating the estate quickly because the executors themselves have a duty to not just keep an estate dormant. It's got to continue to be administered. And there's expectations perhaps maybe of other beneficiaries where that property has to be sold. They want their money.
Yeah.
And so when somebody's clearly not leaving, I mean, there's these instances where you can, again, have those negotiations with them. Perhaps there's an interim arrangement or an interim agreement whereby, okay, by this time, you're going to be paying these rates or otherwise. There could be a general agreement between everybody where everybody says, okay, we're going to do this.
Yeah.
Could be the case where they're going to buy out the estate. So if they really want to keep the property has to be valued. And then at that point in time, there could be an option where that person decides to, okay, well, if I'm really adamant to keep the property, I'm going to buy out the estate. But
should that all be done through someone like you, or if you've got, say, a family member that's lived in the property and they've gone, I was told that I could continue to live here. Don't worry, I'll pay for the rates and all things until we can figure this all out. It's kind of like a gentleman's agreement. Is that should you be doing it through other ways? Like, should we be going to you?
Absolutely. The first thing is to do is, especially if you are an executor, you want to make sure that you're doing things by the book and specifically by the terms of the will. So it's important to get that legal advice in terms of what does the will actually say? Perhaps the will actually gives some sort of right to reside or a life tenancy to this person with specific terms and conditions for them to reside there. Simply coming into these little agreements between them and that person who's residing there is just going to create a bit of a legal minefield and it's just going to blow up into something totally unnecessary. So I'd say get that advice early. Then you know exactly expectations moving forward. What are your options? What are their options? And then to try to get it settled early.
0499 880 882 is the text line. Paul in Underwood has texted through saying, my deceased father-in-law was a joint power of attorney along with his son for the mother. Since the father died, can the son continue at enduring power of attorney, even though the enduring power of attorney was jointly held?
So if we're talking about an enduring power of attorney, that's a document that operates whilst somebody's alive. When that person passes away, that document falls away. All of a sudden, then you're in control of your estate and the executor under your will. But in that instance, it's really going to come down to the powers that they're given under that enduring power of attorney. Specifically, and how that appointment is made. So if there's a joint appointment or perhaps a successive appointment where one person can act, and if they refuse, unwilling, or unable to act, then they've got the reserve attorney who can act on that person's behalf. Again, dealing with those personal and financial circumstances, which will include dealing with the principal, as we call them, the principal's property. So whether or not they need to take steps to sell it or otherwise, or if they choose to rent it out and get some income for them, things like that, or perhaps they're looking to put them. It's that point in time of their life where they have to go into a home, they have to fund a RAD, residential accommodation deposit. The property sold and moving forward from there. So again, sounds like you're probably going to need some advice in terms of making sure that as an attorney, you're making sure those things are covered as well.
Okay, so it's not something necessarily that can just be the whole responsibility moved on to one party or the other.
Again, it comes down to what does the will say? What does the enduring power of attorney say? And making sure you're clearly across those things, because otherwise there could be things that come back on you personally, especially if you are in those representative capacities.
All right, Paul, I hope that has answered your question. Paul from Underwood there with a question. If you'd like to ask Duncan a question, the 4BC open line, thanks to Watch Smoke Alarms, 133 882, or you can text 0499 880 882. I've got to ask, if the situation can't be resolved between all of the parties, what options are there available to executors to move things forward, move them on, maybe in some cases if they're in a house?
Yeah. Unfortunately, it sometimes gets to that point, and sometimes you may need the court's help to break that deadlock, in which case then an application can be made. There might be some sort of enforcement orders. You get a bailiff to come out, and then we get the police involved and remove them from the property. If it gets to that stage, I've been in situations where that is unfortunately the case.
I've been involved in a situation where I was renting a room in a place that got done by bailiffs. It was scary because I had no idea of the situation. That's a story for another time. But if you would see it often, surely. Yeah,
you see it all the time, and unfortunately, it comes to that. And this is what I mean. I think
it's messy and protracted.
Messy, and I think this is just a reminder that during the course of your estate planning, to make sure you have an understanding. Well, do I want to keep somebody in the property? Do I not want to? What's the terms of their continuing to reside there? Who pays for what? Do the estate pay for these maintenance things and the outlays and outgoings? The more clear it is now, the better it is going to be down the track to have something to rely on.
Okay, I've got one last quick question for you, Duncan.
Of course.
This is more personal curiosity. If you potentially feel like there might be conflict down the line over house, property, cash, or whatever it might be, what can you do now to try and prevent that from happening, or if you foresee that happening, to try and stop that from occurring?
Yeah, get that will done. Get that will done. Make sure your wishes are clearly outlined, and it's not something you set and forget. It's something you're going to have to revisit every 2 to 3 years because circumstances change, family dynamics change. More importantly, specifically for blended families, I see it all the time where you've got they have a surviving spouse. They may not be the mother of of the children there as well. But you still want a roof over their head.
Yeah.
For example, so there could be some sort of right to reside there when really you want that property to revert to your children.
Right.
But at least there's a bit of a plan of attack here on what's going to happen down the track to avoid a bit of a blow up and things turning pear-shaped.
Fascinating stuff. I know that you would see a lot of it. Duncan, thank you so much as always. If you want a question ahead of time, you can email us afternoons@4bc.com.au. Attwood Marshall Lawyers Estate Litigation Senior Associate Duncan MacDougall. Thank you as always for coming in, and we'll see you next time.
See you next time. Cheers.